So today we've taken the time to have a conversation with Andrea. Andrea specialises in family law, and we are dealing with wedding season in South Africa. And leading up to wedding season, I have a lot of clients that are planning to get married or are engaged to get married. And one of the key questions that we get a lot of, especially in terms of completing paperwork, the offer to purchase, is actually marriage regimes and the implications of each sort of marriage regime, that the client should be looking at. And, it's not my area of expertise. So I thought having a series on this and speaking to one of the experts would be a really good starting point in terms of letting our clients know what the different options are and what the pros and cons of each are. So I thought, let's have the conversation.
Okay. Thank you, Tanya. So in South Africa, we have 3 matrimonial property regimes. You have your in-community of property, you have out-of-community of property with the accrual, and then out-of-community property without the accrual. In-community of property, generally the default position, if you don't conclude a contract, where each party separate estates, once they get married, would form part of a joint pot, and that pot is divided on dissolution of the marriage, either by death or divorce, equally between the parties if it's on a divorce. The main factors in terms of a marriage in community of property also to bear in mind is that the parties need each other's consent for any transactions that they're concluding, agreements, etc., credit agreements that they're going to get involved in, and also the liabilities. The liabilities of the estate or of a spouse becomes joint. So that's one of the major. If a spouse is sequestrated, one spouse is sequestrated, that means that the other spouse is implicated and affected by that, and the joint estate is sequestrated. So that's one of the main issues that
Just to add on to that, what I've heard is when you marry community of property, that you obviously both need to sign when you're selling a property, and obviously if we at the stage of purchasing a joint property through me. But let's say if the client 3 years down the line is now married and decides to purchase another property, that they wouldn't need their spouse to sign, only when they dispose of the asset would the other party need to sign. Is that correct? Or do they always need to sign all agreements all the time?
Yes, so all agreements, if you're married in community of property, each transaction needs to be dealt with jointly. So you cannot dispose of an asset without your spouse's consent. If you do that, it's going to be void and it will be set aside.
Okay.
They do need each other's consent. So that is one of the main, I suppose, downfalls, if you see it that way, depending on how you look at it. Yes, and then I think that basically covers your in-community of property marriages.
And not so popular anymore?
No, not really. I would say the most common is marriages out of community property with the accrual system. That's where you have a sharing of the assets during the marriage, or the value. We generally refer to it as the value. So what happens with that type of system is the parties have their separate estates prior to marriage. On marriage, they still have separate estates, but the difference is that you could almost see it as a growth. So almost looking at it as, okay, we had separate estates prior to marriage, and now we are married, and we would like to share in that growth, whatever we grow together. It's calculated, there is a formulation that is used if we are looking at the accrual. So the accrual is only comes into play on a dissolution, either by death or by divorce. So your estates are still dealt with separately during the marriage. You do not need each other's consent for any transactions. You can purchase your own property, your spouse can purchase their own property, they do not need each other's consent. They can obviously purchase property together as well, but they'll still be co-owners in their separate estates. So with accrual, you have a calculation that is, will determine whatever the accrual of the parties are. And that is calculated based off of what your commencement value, if anything, is stated in your international contract, with a CPI escalation on that value. And this parties whose estate has a lesser growth will have a claim against the parties whose estate who has a larger growth. And that's the party who has a lesser growth will have a claim for half of the difference of the growth. So that is how it's calculated.
In terms of getting your contract registered, so for example, the clients now are looking to purchase a property and they would be getting married in January, let's say. When is the right time to prepare your antenuptial contract, and how does that process sort of go, or how does it work?
So, an antenuptial contract should be concluded prior to marriage. It can be any time before marriage, as long as it's before the marriage. There's registration of it that is important after you've concluded the marriage. There's obviously certain time periods that need to be complied with, but that's as long as you have entered into an antenuptial contract prior to your marriage, it becomes binding on the marriage. So as long as there's a subsequent marriage, then an antenuptial contract will be enforced. In terms of the consequences of any transactions, as I said, because it's a separate estates, you still deal with your estates separately. It's only that growth and the value of any growth. It's not assets that are divided per se, it is a value. It's calculated on value, but again, it's only if it becomes applicable. Marriages out of community property without the accrual. Again, assets that you had prior to marriage remain each party's assets, and during the marriage, the difference with a system that has the accrual applicable is that there is no accrual sharing.
And you'd still need a contract for that.
You would need a contract for that, and the contract will specifically state that, and you would still go to, so you go to, the parties would need to consult with a notary public with regard to the antenuptial contract, which then gets registered in the deeds office, and it can only be done by a notary public. The parties would as I said, they wouldn't share in any assets, they wouldn't share in any, there'd be no accrual between them. So whatever they had prior to the marriage, whatever they had during the marriage, everything is separate. There has been a very interesting development in the law where prior to the 1st of November 1984, when it was in the Matrimonial Property Act came into effect, there used to be a redistribution of assets on divorce. And the system where you have the accrual without, out of community property without accrual, you do not have any sort of recourse. So generally, if you were, for example, a stay-at-home mother, and now you're getting divorced, unfortunately, you would have no recourse because you concluded a contract where whatever your assets you had prior to your marriage will remain your assets, but whatever growth, however substantial they may be, you wouldn't have any sort of claim. So if you didn't work, for example, you would be very, prejudiced. And so the court found that was unconstitutional, and have now changed the law in terms of if you would like to claim in terms of a Section 7.3 claim against your spouse on a dissolution of the marriage, you can, subject to obviously certain factors, so they look at any sort of contributions that you've made during the marriage, and those would then impact whether you would have a claim. And so now the court, it is at the discretion, the court has discretion as to whether they'll award certain assets or percentage of assets to a spouse if they were married in terms of the out of community property without an accrual claim or out of an accrual basis.